Hi, my name's Brandon. Today I'm going to be doing my Chapter 7 and 8 summary for my business Law 2 class. So first, Chapter 7. Chapter 7 talks about strict liability and product liability. So first I'm going to hit on what strict liability is. So strict liability just overall is just liability regardless of fault. It's just every person who engages in like a certain activity can be held liable for harm of others, even if there is a real good amount of utmost care. He still can be held liable. This is just in certain situations, such like ultra hazardous situations, such as having wild animals. Just something that can, something that's gonna have potential harm to those around them. Then secondly, we're going to talk about product liability in Chapter 7. It's just liability of manufacturers, sellers, or leasers to consumers for physical harm or property damage caused by the goods that the manufacturers produce. Through this negligence is a big thing. This is a failure of due care. So there needs to be a certain due care process through all production, through making the product. Through this, people who seek a remedy, they must show cause and fact. There is no privity required in product liability, so no relationship between the parties is needed, and it extends to anybody who is affected by it. And there's a case in the book about it, about Schwark versus Arctic Cat. So two sisters, Karen and her sister Edith, were riding Arctic Cat snowmobiles when it went reverse and fell off a bluff there, and both of them deceased, and they charged Arctic Cat with negligence. And I think from what I read, the court decided in favor of them. So then there's also a thing how strict liability and product liability, the application between them. So when thinking of strict liability with product liability, there's based on two factors. A manufacturer can bear the cost better by increasing the prices of goods, and they're making profits from the activity, and therefore they should bear the cost of the injury as just an operating expense. So that's how it relates. So that's just a summary of Chapter 7. Next chapter is Chapter 8, and this one talks about intellectual property rights. So just basically what intellectual property is just products of the individual mind, and these are marked by trademarks, patents, copyrights, and trade secrets, as shown in the PowerPoint. So what is a trademark? It's a distinctive mark on a device a manufacturer stamps, prints, or affixes to the goods it produces, just to distinguish it. This is protected by the Lanham Act of 1946. It's just to protect, that act was to protect people from losing to competitors, provides remedies to those. But in 2006, it was ratified for the TDRA Act. It just makes this new ratification just makes owners prove more in court to get the remedy, because before it was fairly easy to just get remedy in court. And when a trademark is infringed, a owner then can take action against. Next would be a patent. This is exclusive right to make and sell his invention for a period of 20 years. Has to be a new or useful process. There's a case 8.11 about infringement. It's Apple versus Samsung. So basically, Samsung copied the way Apple was making their the icons on the home screen, and the jury found that Samsung had willfully infringed on 5 of Apple's patents and awarded them damages. So that is patents. Copyrights, it's just intangible property right granted by federal, state to another literary or artistic production of a specified type. They're protected against things like reproduction of their work, public display. There is a fair use clause, or a person can reproduce copyrighted material without paying royalties, because usually you have to pay royalties. And lastly, trade secrets. This is fairly simple. It's just information of commercial value, like research and development, product list, plans, just stuff like that. So that's just a little run over of chapter 7 and 8 for Business Law 2 class.